Good afternoon, everyone. My name is James Swart, and I'm the Director of Education and Leadership Development here at the National Apartment Association. We are excited that you have joined us for our third and final session in our April is Fair Housing Month content series. Before we get started, just a couple of housekeeping notes. We do have time saved at the end of today's session for questions. So throughout the session, you can use the Q&A panel at the bottom of the screen to submit those, and Christine will be happy to address them once she has finished her presentation. Also a reminder that NAA has several fair housing resources available on our website. I will be putting a link to the main fair housing page in the chat in just a few minutes, so you can visit that page as well as subpages on the NAA website to get more information about both website accessibility, our topic for today, and other fair housing related topics. So for today's session, we are diving into updates to website and digital accessibility requirements with Christine Waltz, who is a attorney with Holland & Knight's New York office. So before I turn the floor over to Christine, I want to remind everyone that NAA's antitrust compliance statement is available on our website. You can view that, and if you have any questions, please feel free to reach out to any NAA staff. Also, a reminder that today's session is not designed to be specific legal advice, but rather informational in nature. So with that, Christine, I will turn the floor over to you.
Thanks so much, James. I'm going to share my screen and then get started. Give me one moment. Okay. Thank you everyone for joining today. As James mentioned, my name is Christine Walls, and I'm a partner in Holland & Knight's New York offices. My practice focuses on accessibility issues, and I work with multifamily providers, operators, managers, developers, to defend against fair housing or claims under the Fair Housing Act and the Americans with Disabilities Act, and also to help I counsel on compliance with those laws as well. Today, just a roadmap for today. The things that we'll cover are first, sort of a level setting on what does digital accessibility mean? What laws govern digital accessibility and how is that changing? What technical standards govern the consideration about what is accessible? What happens when a website is not accessible? And what can multifamily operators do to minimize their risk of litigation in this space? So first, what does digital accessibility mean? We know that accessibility in the brick and mortar context means things like for the most part, what makes properties accessible to individuals that use wheelchairs, although it can also address other types of disabilities. In the web context, web or digital accessibility means that websites, tools, apps, and other technologies are designed and developed so that people with disabilities can use them and use them in the way that they are intended to be used. The federal government has said that accessible in this context means that individuals with disabilities are able to independently acquire the same information, engage in the same interactions, and enjoy the same services within the same time frame as individuals without disabilities, with substantially equivalent ease of use. And so when we talk about website accessibility, there are a number of laws that impact what is required, especially in the housing context. And that is changing because we are now seeing a number of state-specific laws that are coming in and overlaying on the current framework. So the laws that have requirements for website accessibility include the Americans with Disabilities Act, state public accommodation laws, the Fair Housing Act and similar state laws, Section 504 of the Rehabilitation Act, which applies to any entities receiving federal financial assistance. And then again, we are seeing state-specific laws addressing website accessibility. The Americans with Disabilities Act applies to places of public accommodation. And it provides that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation. Places of public accommodation are places that are open to the general public. And actually, multifamily housing is not considered a place of public accommodation for the most part. However, to the extent leasing offices and the facilities serving leasing offices, as well as any other mixed use spaces that you might have at a property, that are, again, open beyond just to residents and their guests, but are open to the general public. Those are places of public accommodation. And under the Americans with Disabilities Act, a public accommodation is required to provide appropriate auxiliary aids and services where it's necessary to ensure effective communication with individuals with disabilities. The Americans with Disabilities Act has been federal law since 1990, and so it predates the internet, at least as it exists today. And so as a result, the statute itself does not expressly address whether websites are required to be accessible. Instead, it talks mostly about brick and mortar facilities. However, notwithstanding this statutory silence, the U.S. Department of Justice has taken the position that the ADA applies to websites of both public entities as well as places of public accommodation. And they use that portion of the statute that addresses auxiliary aids or auxiliary aids or services. It uses that requirement to reach into websites and say that websites are also required to be accessible. Under the Americans with Disabilities Act, the remedies are limited. These are not cases, or the law does not allow for damages to be recovered. Instead, it is limited. The relief that is available under the statute is injunctive relief. So the court can order a defendant to undertake efforts to make their website accessible and adopt policies and practices to ensure that the website remains accessible, but a plaintiff cannot seek damages. However, the court can award a prevailing party their attorney's fees under this statute. In addition to the Americans with Disabilities Act, most states have public accommodation laws. And today I've identified two that you should be aware of, although depending on what state you're in, these are, you should consider the state laws that may also have requirements for website accessibility. Under California law, the California Unruh Civil Rights Act requires that, or prohibits discrimination by all business establishments in California. And a violation of the ADA is a per se violation of the Unruh Act. And unlike the Americans with Disabilities Act, the California law, in addition to providing injunctive relief, also allows for actual damages as well as statutory damages and a recovery of attorney's fees and costs. Likewise, New York has a similar law that prohibits discrimination by places of accommodation. Most states are going to have laws like this. And so these are additional causes of action and additional state requirements for accessibility. Additionally, multifamily providers are covered by the Fair Housing Act. I think most people on this webinar are going to be familiar with the Fair Housing Act. It covers most housing and it prohibits discrimination based on any protected characteristic. And one of the protected characteristics is based on a disability. Under the Fair Housing Act, or the Fair Housing Act prohibits discriminatory advertising, which is making any statement that expresses a preference or a limitation based on any protected characteristic, including disability. It prohibits refusing to make reasonable accommodations or modifications needed to allow equal enjoyment of a property. It prohibits offering different terms and conditions based on a disability or otherwise making housing unavailable on the basis of a disability. And so while we have not seen a lot of case law on this point, based on the plain language of the statute, I think there are a number of arguments that could require or could make it a violation of the Fair Housing Act to not have a accessible website, for a multifamily provider not to have a website, or not to have an accessible website. And unlike the ADA, the Fair Housing Act does allow for the recovery of damages. So those are the broad statutory requirements that are generally used to say that websites need to be accessible. But what does it mean for a website to be accessible? Currently, there are no specific technical requirements from the government outlining what is required for private websites and mobile apps to comply with the Americans with Disabilities Act and these other laws. We are starting to get a little bit more guidance in the form of actual standards from a variety of sources, which I will address. But right now, we, again, because of the age of the statute and the way that the government has issued rules and regulations around this, there is not, again, binding guidance about what is required for accessibility. This is very different than what we see under the Americans with Disabilities Act requirements for brick and mortar facilities, which have very detailed requirements about what it means to be accessible. A few years ago, in March of 2020, we had guidance from the Department of Justice about website accessibility. And this was after a long period of silence from the government, including a decision in 2017 by the Department of Justice to shelve their plans to issue regulations addressing the technical requirements for website accessibility. In the 2022 guidance, the Department of Justice said that it is their view that accessibility is required under the law, and that one way of developing an accessible website is to comply with the website content accessibility guidelines, which are the WCAG or the WCAG guidelines. And however, the government said that there was flexibility in how they can comply, and that they could ultimately, and the businesses could ultimately choose how to ensure accessibility. While they have said that, every settlement that we are aware of, either in the form of consent decree from the Department of Justice or private consent decrees that we know of, has required compliance with the WCAG 2.0 or 2.1 level AA standards, which we can talk about a little bit more in a minute. And the government's suggestion that there are other ways to comply has really just been a question mark, because they have not pointed to anything besides the WCAG guidelines for what could be what would be deemed accessible. As a result, we're in somewhat of a unusual posture here, legally, where we have what has happened is that a cottage industry has developed, with plaintiffs filing lawsuits against companies for alleging that their sites are not accessible to individuals with disabilities. But there isn't a clear standard. And so for the most part, these lawsuits are settled because they are because the fee shifting provisions of the Americans with Disabilities Act really encourages settlement. And I think most businesses want to make sure that their websites are, or their products generally, are accessible to individuals with disabilities. But we are seeing some additional legislation and regulations be offered in order to put some more meat on the bones and explain exactly what is required for website accessibility. So up on the screen right now are a few laws that are in the works that would, for the most part, expand or clarify the requirements as they currently exist. And again, provide a little bit more structure to what the legal requirements are. Additionally, last week, the Department of Justice issued accessibility requirements for state and local government websites that those exist under Title II of the Americans with Disabilities Act, as opposed to private websites, which fall under Title III. As was expected, the Department of Justice, the standard that is adopted is the WCAG 2.1 level AA. Interestingly, these regulations include some specific exemptions for archived content, for existing electronic documents like PDFs that might exist on a website. They include exceptions for some third-party content and for password-protected documents and pre-existing social media posts. So in a lot of ways, they're looking, the Department of Justice is trying to say, for state and local governments, okay, we don't have to go back and address everything that's already on your website, but going forward within the next 2 to 3 years, we want your current content on the site to be made accessible. There is also a general exception in these regulations in the event of technical non-compliance. If the non-compliance has such a minimal impact on access that it would not affect the ability of disabled persons to use the web content or app. And so this exemption is, I think, really, I think it's designed to help businesses who oftentimes feel like the lawsuits that are coming are sort of gotcha lawsuits, right? That companies are undertaking a lot of work in order to make their sites accessible, but content is added to a site daily, and sometimes things are gonna fall through the cracks, and there are always bugs to a site. Those exist both in the accessibility space as well as just anytime you're using and anytime you're developing a website or an app generally. So I think this exception is designed to say, well, what are the true, what deviations from the WCAG 2.1 level AA are, uh, what deviations are true barriers to access, and what deviations might really not impact accessibility very much. The exception is going to require, relying on the exception would require showing that disabled and non-disabled individuals would have substantially equivalent timeliness to the site or to the use of the site, privacy, independence, and ease of use, and can access the same information, conduct the same transactions, and otherwise participate in the entity's services or benefits to the same extent. And so again, that goes back to sort of the definition of accessibility from the government, right? Which is that we want the site to be able to be used in the same way by disabled individuals as it is by non-disabled individuals. So as I mentioned, all of the statutes, all of the settlements, all of the regulations, everything points to the WCAG guidelines as the de facto standards that businesses should be meeting for website accessibility. And under the WCAG guidelines, there are 3 tiers of compliance: level A, level AA, and level AAA. The highest, most complex level of accessibility is going to be level AAA. No one has required that yet. Instead, we see this level AA, this middle standard, as the sort of governing standard. Unfortunately, the guidelines are written just like that. They're written as criteria for businesses to use and to be aiming towards, but they are not written the way that a law or a regulation would be written. And so it is still very difficult to sort of comply 100% with the guidelines because they're not written that way. But they are what we have. And so we can talk more about policies and procedures and ways to incorporate them into your business practices. But they are still an imperfect standard. And that has commentators saying that this is not really the best way to create law, right? It would be much better if we had a clear legal standard that was written in the way that a legal standard would be written, but it doesn't appear that we're going to get that. And so the technical guides are sort of the best that we have and the best I think that we're going to get. Under the WCAG, there are 4 foundational principles that content on a site should be perceivable, operable, understandable, and robust. This largely means that most of this is about how the technical requirements are about how our back-end requirements, right? There are things that are located in the code of a site that allow individuals who are using assistive technologies like screen readers or screen enlargers to interact with the website. And so each of these are the 4 principles, and then they are broken down into specific success criteria. How this comes up in my line of work is where we see where it's not working. So we have plaintiffs, and we can talk more about the number of lawsuits that we're seeing, et cetera. But the types of things that plaintiffs are identifying, saying that a site isn't accessible, the main issues that are routinely called out in legal complaints are a lack of alternative text. So anytime there's an image or a video on a website, it should have alternative text that allows a screen reader to say what the photo is. And I do see this more and more, both in the back end of websites in terms of what's in the code, what the alternative text is on websites, but also in terms of social media posts. Just like captioning has gotten much better over the last few years, we are seeing, I think, just individual social media users providing alternative text in their comments or in their caption on Instagram or other sites. It's supposed to be specific. It's supposed to really give you an idea of what the picture is showing, a detailed description of what is in the photo or the video. Insufficient color contrast between text and background. A lack of captioning for video content. So anytime there's a video on the site, there should be a way of seeing or hearing that content because it is translated into text format, either through captioning or through a PDF or other kind of document with a transcript. Headings that are empty or are not logically sequenced. So this is really about having a clean website that in the code establishes how you're to read the site and understand the content on the site. And so if there's headings that are not properly used, it makes it much more confusing and clunky for an individual with disabilities to use their screen reader to navigate the site. The same thing happens with empty or redundant links, where if you click on it, it goes nowhere. And that just makes the site less usable, both to individuals with disabilities and to individuals without. And then page functions that lack keyboard functionality. That is, typically the site is required to, or should have the ability to use a keyboard rather than a mouse to navigate based on how, again, the screen reader is interacting with the site. I've included some links here in the PowerPoint that talks more about all of the specific requirements. So it's about 2:30 now. So we're about halfway through, and I'm going to turn to what we're seeing in terms of lawsuits, and then we'll turn to some of the practices that companies can undertake in order to minimize their risk of lawsuits in the space, or position themselves so that they're in a position to defend those lawsuits. So what are we seeing in terms of lawsuits? Initially, I would say around between 2010 and 2015, there were issue-based advocates like the National Federations for the Blind and the Deaf that were bringing large litigation against a number of companies that about the content on their website. There was the Netflix case and the Scribd case, both of which were online only businesses. And these groups sued and said the content on your site needs to be accessible. And the company said, no, we're website only companies. We are not public accommodations under the statute, and the site and the content doesn't need to be accessible. And in both instances, courts said, no, you do, right? Netflix is a modern movie theater, which is certainly a public accommodation, and Scribd is a modern library, also a public accommodation. And therefore, like, the content on the sites needs to be accessible. Again, that was back 2010 to 2015. That's when we were seeing those types of cases. More recently, we are seeing individual plaintiffs represented by a few firms bringing cases against any website. They typically seem to pick an industry and then sue a whole bunch of and companies within that business, all in a stream of lawsuits. So first it was banks, and then it was retailers, and there was fitness studios, right? That seems to be the pattern or the trend. They are largely testers, going in and saying, we would like to use your site, we would like to frequent your business, and because it's not accessible, we're unable to, and therefore we are harmed. The case law is, at least today, pretty clear that testers do typically have standing. There are a number of sort of boxes that they need to check in order to sufficiently plead standing. But for the most part, plaintiffs have figured out how to do that, certainly in a complaint, and courts have accepted that. The Supreme Court recently had the opportunity to consider tester standing in a case involving a hotel and a hotel's website, and they declined to do so. And so we may see the Supreme Court take that up again, but there were some technical issues in the case, and they decided not to hear it. In terms of what we're seeing on the ground in lawsuits, I would say that we are seeing cases brought in a few states. We are seeing, I'm based in New York, and we see a lot of lawsuits filed in federal and state court in New York. So Southern District, Eastern District of New York, and state court in New York. That's because there's some really good case law for plaintiffs in these jurisdictions. And so plaintiffs are suing here. We also see case law or cases filed in California, mostly in state court, although occasionally in federal court. And I have seen Pennsylvania as a new hotbed for this litigation. I would say that there are dozens of lawsuits filed every day. I do track the federal cases that are filed, and again, dozens filed every day. 80% of lawsuits are brought by the same top 10 plaintiffs' law firms. And in addition to the cases that are filed, we also know that claim letters are sent. There's probably thousands sent every year, but there's no way to monitor exactly how many of those there are. I pulled the numbers from February of 2005. there were 316 lawsuits alleging that websites were not accessible filed in February of 2024. 50 of the defendants that were sued had previously been sued in a digital accessibility lawsuit. 55 of the companies that were sued had been using an accessibility widget on their site. I mentioned the states that we see the most filings in. And again, it is a highly concentrated plaintiffs bar. I wanted to note one particular case, because as I mentioned, with the guidelines and with the constantly changing digital content, it is challenging to have a site that would be sort of 100% in compliance with the WCAG 2.1. And unfortunately, we don't have a lot of, we don't have guidance from the courts as to what exactly is required. Is it 100% compliance? Is it, well, it's 80% and there's no major barriers? And we just don't have that, except that in June of 2022, there's some good case law for companies out of California, where the court said, okay, some of these issues, they might not strictly comply with the WCAG 2.1, but we think it's close enough. We don't think these are true barriers to access. They looked at text elements, script elements, and contrast issues, and they said, essentially, like, we think this is good enough. However, the court did reference menu barriers and said that menu barriers on the site would have rendered the website unnavigable, and that would be a barrier to access. So we are starting to get some guidance from courts. But so what can you do within your companies in order to mitigate the risk of litigation? It's very difficult to avoid litigation altogether, but you can certainly take steps to both maybe avoid it because the plaintiff decides there are more companies that are less compliant than you and sort of easier cases to bring. But what you can do is prepare yourself for defending the litigation. And I would also take a step back to say that in addition to mitigating the risk of sort of tester litigation, it's also like you're all in public facing businesses with residents with disabilities. And it is, those are residents that you want to be able to reach. And so we can talk a little bit more about that, but there are obviously reasons to have an accessible site beyond just avoiding litigation. So as you are evaluating sort of what to do to work on website accessibility, or to consider how to comply. First, you have to identify what are the digital platforms and how are residents or prospective residents interacting with your company's digital platforms. So there's a public facing website. That's one item that can be accessible. There's probably a resident portal where residents are going to interact with the company once they have already signed their lease, right? Are they paying their bills there? Are they looking up their utility payments there? Are they submitting maintenance requests through the portal? Is there a mobile application? What web content is there to begin with? And can you work with your team to identify that? Then, once you've identified the various platforms, each platform should be tested. There are online web tools that are pretty good, that are the things that plaintiffs use. And so that can give you an idea of like where there might be risk. There are also a number of accessibility consultants in the space that are available to do full audits. Those audits can both use mechanical tools, but also disabled individual testers that will test your site, just like a secret shopper would test your leasing office. Based on all the guidance that we have, we recommend focusing on the WCAG 2.1 level AA for web content. You should consider your approach to archived materials and third-party content. Archived materials, we have, at least from the Title II, in the Title II context, the government seems to be taking the position that's sort of that archived material doesn't need to be updated to be accessible. So that's helpful guidance there. Third-party content, the government is saying, well, is it really third-party content? Right? So if it's truly third-party content that you are leaving your website and going to another website, okay, that can be third-party content. But if there's a contractual relationship between the companies and maybe there's a vendor that's handling your payment system for rent, that is not going to fall, that is not going to fall within third-party content, and the company that is facing the user there, probably, I think both parties could be on the hook there. And so you have to take a look at that. Think about, again, how are prospects and residents interacting with your website or your digital platforms, right? So do you have virtual tours? Are those tours accessible? Can they be made accessible? There are a number of vendors that are developing online tours that are accessible, and they will, and so that's something to take into account. What about how residents are interacting? Are the forms used to pay bills online, to pay your rent online, is that accessible? How can it be made accessible? And what feedback are you getting from your residents or from your prospects? If someone's saying something's not accessible, what forum is there for that information to come to you and to be acted on? So, and okay, sorry. So are you testing your site? Are you monitoring your site? What training programs do you have for internal employees that are working on these issues? Most of the people that are developing websites understand the need for them to be accessible and understand what the requirements are. If you're using an outside vendor, are you requiring them to make the site accessible in accordance with, or in your contract documents? What policies do you have, and how are you taking feedback from users? And again, how often are you continuing to test your site, and how are you documenting that? Because these lawsuits do come fairly routinely, and having something to defend yourself with, to show, yes, we test our site quarterly, we create a workflow based on any issues that are identified, and they are promptly taken into account or promptly incorporated into the workflow and addressed. Okay. And then, what do you do if you get a lawsuit or a demand? These are tough cases to win, because again, the standard is not clear and the plaintiffs have some good case law on their side, and it is 2024, and a lot of I think it's important to say we are trying to reach our disabled residents, and here's what we're doing to reach them. And rather than taking a position that a site doesn't need to be accessible. In 2024, that is largely a hard argument to make. So if you get a lawsuit, definitely reach out to a lawyer, whether you're in-house counsel or your outside counsel, immediately, so that things can be responded to in accordance with the various court deadlines. We typically recommend considering whether there's any defenses that can be raised on a motion to dismiss. Are you being sued in the right jurisdiction? Did the plaintiff really have standing? For companies like you, like companies like multifamily operators, you probably have some record of whether an individual has actually come to your site or is living at your property. And so you might be able to say that the allegations are insufficient to establish standing or harm. Mootness, can you say that any issues have already been addressed? And are you in a position to demonstrate that your site is accessible? That goes back to documenting what your processes are and what steps are undertaken to make the site accessible. In my experience, the settlement negotiations in these cases typically revolve around how much of a monetary payment is going to be made, what modifications the defendant will agree to make to the website, and what the time frame is for making those changes. We also see a number of these cases are filed as class cases, class actions, but they are typically settled on an individual basis, which means that companies could settle one case and then be sued again by another plaintiff. And so if you're not addressing the issues that are identified, you could face more than one lawsuit. So I'm going to stop. Why don't I stop and take, so I'll stop for a second and see if there's any questions. And then we can do a couple of takeaways. You can put your questions in the Q&A box.
And Christine, we might take the lack of questions as a testament to the thoroughness of your presentation.
Okay, so we can do some takeaways and then see if there's any questions at the end, but this all looks good. So a few takeaways for us. The best thing you can do to avoid litigation and to prepare for litigation or prepare a defense in litigation is to be doing what you can to comply with the legal requirements now. Take action, figure out what's going on both internally and externally, and get your site in good shape to hopefully avoid litigation altogether. This is also one of those areas where everyone should be working together on accessibility, right? So this touches on a whole bunch of different areas within a company. We see it with property management, right? Who's on the ground? IT, what's going on in the back end of the website? Legal and compliance. We don't want lawsuits. They cost money. Risk management. Is this a reputational issue? What can we do? And external consultants and audits, right? Are we working with our vendors? Who's testing the website? What can we do to put ourselves in the best position going forward? So if everyone works together, that is the approach that we recommend. There is absolutely a business case for accessibility, right? Many individuals have some sort of vision or hearing impairment and can only access a site when it is designed in accordance with the WCAG 2.1 level AA, right? So we want to be reaching all of our residents and so there is absolutely a business case for accessibility. It is also something to adopt now. The business case, in addition to being important to reach all of our residents, there's also a business case in litigation avoidance. If you do not think that any digital platforms that your company has are accessible today, you should expect a lawsuit because the plaintiffs are extremely active and they will come to multifamily and file a slew of lawsuits, and you will then have to address the accessibility if you haven't addressed it already now. Additionally, we are seeing stricter regulations on the horizon, and that will only bolster plaintiffs' cases and will ultimately probably have them seeking more money, not less, in order to settle the matters. If you receive a lawsuit, please contact experienced legal counsel. These are routine, but if you work with someone who's handled them before, you should be in a position to resolve them pretty favorably, pretty quickly. And your in-house teams should also be able to, or should also be your first call. And consider, as you're entering into relationships with different partners on your web design, consider consider engaging with web accessibility partners for technology, training, and other support. They are out there, they're doing good work, and you should rely on that. One last call for questions. Okay, seeing none. I'm Christine Walls, and if you have any questions going forward, my contact information is on the board. We work with NAA all the time and are happy to talk to any multifamily providers if y'all have questions.
Christine, thank you so much for joining us today and sharing your expertise. And thank you to everyone who logged in. A recording of today's session will be made available in the next couple of days on the NAA HQ YouTube channel. So please check back there for this recording, as well as recordings from our other April is Fair Housing Month sessions. With that, have a great rest of your afternoon.